to the fourth unit called as Economic Laws. So the contents of this chapter are, we're going to study the Indian patent laws according to WTO patent rules and also in detail the FEMA Act, which stands for Foreign Exchange Management Act, which was replaced by FERA. So before we go into patent in detail, first let's study what is intellectual property. Commonly called as IP, it is a category of property that includes intangible creations of a human intellect. What is IPR? Intellectual property rights. It refers to the legal rights granted with the aim to protect the creations of an intellect. So what is intellectual property? It is a property which includes what? All the intangible creations. And what is IPR? That is the right. If you have invented something, if you have designed something, right, it gives you the right, okay, granted with an aim to protect the creations. If you have invented something for the first time, you got to get the rights in your name. Otherwise, somebody else is going to take that credit. So it's going to, once you get your name on the design or that you have invented so and so work and so machine or a technology or a software, right? So it gives you a legal right that nobody else can copy your work or nobody else can do your work, right? It is only you have the sole authority that you have invented it, and it gives you protection rights. So that's what is intellectual property about. Let's look at the types. We have commonly 4 different types of intellectual property: patents, copyrights, trademarks, and trade secrets. So in this chapter, we are focusing on patents, but just let's look at what is the meaning of the other 3 things as well. That is copyrights, trademarks, as well as trade secrets. Now this is a picture of various products from food, FMCG to beauty products or to softwares or to sports, right? Now here we have a lot of things that you can see. We can see company Apple and its slogan. We can see company Nike and its slogan and its symbol, right? We have KFC, we have Coke, McDonald's, L'Oreal, etc. Now, what you see is each, can you differentiate, even though there are almost 7 products or 7 companies displayed on the screen, yet you are able to differentiate what is what company, I mean, which company sells what, right? We have KFC selling, belonging to FMCG. We have Apple that belongs to a software industry. Are you able to differentiate? Yes or no? Are you just, even if I don't put up those slogans, if I just put the Apple symbol there or the correction symbol, that is the Nike symbol there, or that KFC, that person's picture there, you will still be able to identify this symbol belongs to this company. This symbol indicates this industry. Yes or no? What am I talking about here? Trademark, right? Trademark. See, every company has its own font size of images or slogans or symbols that enables the consumers or the customers to differentiate. The idea behind a trademark is to differentiate, for people to be able to identify an individual company uniquely, right? I cannot mix one company with all the others. If your company has to stand out among all the other competitors, you need to have a separate company name, existence, symbol, slogan, a word, a symbol, etc. So a trademark is simply, the very purpose is to prevent the confusion between the goods and services of one brand to those of others. Here also we have certain names that is displayed there from Amazon, Adidas, YouTube, right? Coca-Cola. What are all these? The way that the way those words are written, the color of those words, the symbol, the slogan, what does it benefit you as a customer? You as a customer can identify or can differentiate from one product to another, from one brand to another, right? And these trademarks can differ from software industries to online shops, or to food industries, etc., right? Giant industries or companies have been established with a reputed name or a slogan or a symbol, what you can see on the screen. From ages together, from the when they have established, this has been their identity. So trademark in simple gives a company or a corporation an easy identity. What does trademark do to the customer? It helps the customer to differentiate or identify easily. Is that clear? For a company, it gives an identity. For a customer, it enables you to differentiate the goods and services provided. So that's about trademark. So here, what can you see? Copyrights, right? Now we know that it's Walt Disney who introduced certain cartoon characters, right? So copyrights are those, if you have introduced it for the first time or you created something. It can be a work of art, it can be work of music, it can be a recording or a video, or it can be artistic drama, literary like poems or books or novels, etc. All these things that you see on the screen belongs to copyright. So it is an exclusive right to print, publish, or record. So this right lies with the author for lifetime. So if anybody has to use their copyrights, they definitely have to pay the author, right? So this copyrights is an exclusive right to print. Either you can print in the form of books, right? Publish it, and you can earn money, or you can record it in terms of video. If creating a particular video is your copyright, first time that you have done, so that becomes a copyright. Is that clear? So that's the second intellectual property, copyrights. So what symbol that you can see at the bottom of the slide is C. Within a circle there's a C. That's the symbol where you see as copyrights. Okay, so every time you see certain shows or certain artwork or books or novels, etc., you can find the symbol at the top or anywhere around the introductory page, which says it is copyrighted. That means all rights are reserved. Number three, we have trade secrets. Now we see that these two people on the screen are exchanging something in secret. Now, what is a trade secret? It is techniques used for manufacturing a product. Can you see those things on the screen, right? What is the formula to prepare Coca-Cola? That is like the Coke, the drink, right? These are called as trade secrets. Simply, it is the techniques used for manufacturing certain products, and you cannot definitely these companies are not going to sell those ideas or reveal those ideas. It is very confidential. Now because of the secret, this company is able to outstand the all the other competitors in the industry, right? Example, Coke. Now the way Coke taste, right? No other drink can give it. Yes or no? That means this is a trade secret of the company Coca-Cola. That completes your third point, which is called as trade secrets under intellectual property. Next comes list of inventors and their invention. The moment you see invention, the first word you need to remember is patent. Okay. Now all these images that you can see, who found out, who invented a telephone? It was Alexander Graham Bell. Who invented the light bulb? Thomas Edison. Who invented the steam engine? It was Robert Fulton. Is that clear? Now this belongs to patents, something that you've invented for the first time and it was not there anywhere in the past or any work done in the past decades. Okay, a patent must be absolutely new and must not be, you must not copy somebody else and try to introduce, right? It can be addition to it, but you cannot copy it. Is that clear? So this is a patent. It is a form of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention for a limited period of years in exchange for publishing and enabling public disclosure of the invention. Now, let's say you have invented something, you've invented a computer or a software. You need to go register yourself under the Patents Act and make sure you have to explain yourself how you identified it or how did you invent it, what is the entire procedure, right? Now once you get your idea or once you get your work patented, what does it enable? If you are the owner of the patent, it enables or gives you a legal right to exclude others. So can anybody else use your invention? No. They are, if anybody else uses that, it is called as infringement. Okay, illegally if somebody else is using my invention, that process is called as infringement. So once you get it patented, nobody else can make the same product or design or use it or sell it for a limited number of years. So there's a limit to patents over here. Now this patents is covered under the act called as the Patents Act of 1970. It extends to whole of India. We have seen n number of acts that we have studied, laws that excludes Jammu and Kashmir. You remember that, right, from the Indian Contract Act that we studied. So here this act, that is the Patent Act, enables or it covers to the whole of India. That means it includes even Jammu and Kashmir. It shall come into force on such date as central government may publish in the official gazette. Now here, when does the patent become official? Right when the day you have given all your work, your explanation, and given your application for getting your work patented. Now in case you have an invention, you have a work or a design that you need to get patented. What is the criteria to get your work patented? Number one, it must be absolutely new. Novelty means what? New. Nobody else in the history must have observed that or identified that or even invented that. You must be the first and the sole person who has invented it. Okay, it must be completely new. That's the first criteria for a patent to be accepted. Number two, utility or usefulness. Okay, now here the second one talks about your invention. Yes, you've invented something good, but how far has it been useful for, let's say, for industrial purpose or for a household purpose? Let's say you have invented a dishwasher. Now, is this dishwasher actually put to use, or is it just a theory? Can that machine actually wash the dishes, or can it actually wash certain plates or glasses? Is called as utility, right? Can your invention be useful to others? Is that clear? It can be a machine, it can be a design, etc. Is it useful for others? Is that clear? So that's the second criteria for utility. Third one is non-obvious. You cannot come up with something which is very natural or something that somebody has already invented and you just try to override something over that and say that you have invented it. No, it should not be. No, it should be non-obvious. Okay, some, if everybody is getting the idea, if things are very common, if your idea or your work is very common among people, it's obvious, correct? It's obvious that everybody would come up to a certain idea or certain work. Your idea or your invention must be non-obvious. right? That means your thought process or your work in certain inventory, certain machine, or certain design must be non obvious. That means you must be the only sole person to come up with certain invention. Is that clear? Hope you have understood what is patent, right? Under which act it is being governed, and what are the three basic elements to be accepted. That is novelty, utility, and non obvious. There are two types of patents. One is utility patent and one is design patent. Utility, as I told, usefulness of a product. How does the product work? The working of the product. If you are able to invent something, criteria to how can a product work better or work efficient, right? That belongs to utility patents. On the other side, you're just working on the outset, not the inside working the product, but how does the product work on the outset, right? That is the design of the product. Then it is called as design patents. Understand? Two types of patents, utility and design. So there you can see the two pictures, correct? The one picture is bike. Now in this, the first picture, we are focusing on the engine, where it has to be placed or how it should be working, etc., which is called as utility. I'm focusing on the work, okay? The tire, the stripes of the tires, or the all the placing of engine, placing of oil tank, etc. I'm focusing on how the bike has to work. The second picture, can you see? It is only showcasing you the design of cars, right? All the cars, of course, will have engine. All the cars, of course, was going to have the oil tank. But I'm just working on the outside. That is the looks of the product or a commodity. Now, can you see the different designs of a car over there? Although the names of the cars are given, just look at the design. Each car design is different from the other. That is what I'm talking about, design patents. Utility works on the utility focuses on the usefulness or the working condition of a product, whereas the design patents works on the outside, right? The design of a car or the design of any other machine, etc. Only the looks. I'm focusing on the how the product is going to look. Is that clear? So this is just an introduction about intellectual property, and also we just had an overlook about what is, we started off with four types of intellectual property. The first one was a trademark, right? It refers to slogans, symbols, and names of company, brand names of company. Then we looked at copyrights, that can be working to literally artworks, music, artistic, dramatics, and recording. Next, we looked at trade secrets, which refers to the techniques used for manufacturing a product. The best example is Coke. Number 4, which we are going to study in detail for this chapter, is patent, right? Inventions. Patent, the immediate word you need to remember is inventions. So here we studied about the meaning of patent, under which act is it covered, and what are the three basic elements for a patent to be accepted, and the two types of patents, and the lifetime. If you are an inventor and you invented something, you will have a lifetime period. You will have a patent period of 20 years. After 20 years, nobody else can use your work or your invention. After that is what they can be using your work. Is that clear? So this is just an introduction about the chapter economic laws, under which we have started the intellectual property.